My name is Doug Oles, and I'm a neutral at JAMS who does arbitration and mediation. My own expertise, such as it is primarily in the area of contracts. And I've spent 30 years litigating contracts, negotiating them, writing them, and I'm, I believe, familiar with the basic rules of contract interpretation as laid down in the United States mostly by the common law as opposed to by statute. I do have a particular background in construction law, and the laws governing construction go well beyond the ability of a neutral person to simply read the contract. There are both statutes and common law limitations that need to be taken into account. And I think it's helpful in a construction dispute if the neutral is familiar with that legal framework. I think the success of mediation arises from the fact that it allows parties not only to reach an accelerated settlement and save legal costs, but also sometimes to structure the settlement in a way that a court couldn't do, and a way that maybe even allows them to preserve a business relationship between the litigants. Preparation for a mediation is actually one of the most important things. Most lawyers are familiar with the idea that they submit a summary to the mediator several days before the mediation, but there's actually a lot more that needs to be done, and that's to try to structure the mediation to make sure that it's occurring at the right time in the process, and that the parties are properly prepared for what the process has to offer. Whereas a mediation is sort of like holding up a mirror to the strengths and weaknesses of a case, I think of arbitration as being a scale. It's a proceeding in which the arbitrator not only has to balance the evidence and come up with a reasonable conclusion, but the arbitrator also needs to give parties the assurance that their position is being heard, so that even the losing party will go away feeling that the process served him or her fairly.